Hi, my name is Andrew Meinzer of Meinzer Law Firm PC. Today I'm going to talk with you about what it means to have capacity or lack capacity for conservatorship court proceedings and trusts and other documents. I'm not going to explain in this video what conservatorship court proceedings and trusts are all about. We've published many videos here that explain them in detail. This is the first video of a three-part video series. Here and in our next two videos we'll discuss capacity and lack of capacity. Consider issues of capacity from two different directions. One, you may want to take over the affairs of a friend or loved one through a conservatorship court proceeding, trust, or power of attorney. You may need to do this when your friend cannot manage her own affairs. In these cases, you normally need to establish that the friend lacks capacity or is incapacitated. Or two, you may want to create estate plan documents for yourself, such as a trust, will, and powers of attorney. Through those documents, you plan ahead for what you want to happen if you become incapacitated in the future. You cannot sign these documents unless you have sufficient capacity. According to California law, capacity is the mental and physical ability to make a rational decision. That includes the ability to perceive and appreciate all relevant facts. So, capacity is a state of being. California law contains multiple definitions of capacity and lack of capacity depending on the legal context. And in some legal contexts, California law contains no such definition, even though having it could be helpful. So let's first discuss establishing that someone lacks capacity to manage her affairs. If she's an adult and you want to take over managing her affairs for her, then there are three possible ways for you to do that, or four different ways depending on how you look at it. One is a conservatorship. If the person did not create a trust, power of attorney for financial management or asset management, and/or power of attorney for healthcare or advanced healthcare directive, then a conservatorship court proceeding is the only way that you can obtain legal authority to manage her affairs. A conservatorship court proceeding can have one or both of the following components. Conservatorship of the person. This provides you with authority to make personal care and medical decisions. To be incapacitated to the extent that a court can appoint a conservator of the person, she must be unable to provide properly for her personal needs for physical health, food, clothing, or shelter. Conservatorship of the estate, that's the other part of a conservatorship. This provides you with authority to manage assets and finances. To be incapacitated to the extent that a court can appoint a conservator of the estate, she must be substantially unable to manage her own financial resources or resist fraud or undue influence. You also might be able to manage her affairs through her trust, power of attorney for financial management or asset management, and power of attorney for healthcare or advanced healthcare directive. These are estate planning documents through which someone nominates a person to manage her financial and/or personal care decisions. Normally, these documents do not empower the nominated person to act until the person who created the documents is incapacitated. California does not have a statute specifically defining capacity or lack of capacity that one must establish to be empowered to manage the affairs of another person through each of these particular documents. If these documents are well drafted, then they will define lack of capacity. They also will discuss how to establish the lack of capacity to become able to manage the affairs of the incapacitated person. Typically, these documents require written certification by one or more doctors to establish that lack of capacity. But there's more to the story, as we'll find out in the third and final video in this three-part video series. But first, the next video will discuss the capacity necessary to sign trusts, wills, powers of attorney for financial management or asset management, and powers of attorney for healthcare or advanced healthcare directives. Making a mistake assessing a person's capacity regarding conservatorship court proceedings and trust and estate plan documents could be catastrophic. If a person lacking capacity signs a trust or other estate plan documents, then someone may be able to invalidate those documents when those documents are needed. Hiring an attorney experienced with conservatorship court proceedings and trusts can help avoid a lot of this trouble. In addition, the advice and guidance of an attorney experienced with conservatorship court proceedings and trusts is invaluable for attaining your goals in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients achieve their goals in trust cases and in conservatorship proceedings. Again, I'm Andrew Meinzer of Meinzer Law Firm, PC. If you know that you need our help, or even if you just have a question, please contact us and let us take care of you.